name is Bonaventure. Welcome to our commercial law class. Today we are going to look at the nature of a contract, classifications of contracts, how contracts are formed, also terms of contract, how officiating factors can come about to make a contract not to be operational. In that way, we will talk about illegal contract, also how contracts are discharged, and also remedies for breach of contract and their limitations. So, a contract is a legally binding agreement between two or more parties which starts with an offer from one person, but which does not become a contract until the other party signifies an unequivocal willingness to accept the terms of that offer. That is to say, a contract is a legally binding agreement between two or more parties, and it starts from one person offering an offer to the other, and until the other party agrees to the offer, that contract does not become a contract until the offer is accepted. And acceptance is the final expression of assent to another's offer. But if there is a counter offer, then that contract becomes null and void. And we can also look at the characteristic of a valid contract, because we have seen that in a contract there is a party which makes an offer, and also there is another party which accepts that offer. So if that offer is not accepted by the other party, then that contract becomes null and void. So there must be an offer, and also there must be acceptance. An offer and acceptance. Those two terms are very important in the formation of a contract. So the characteristics of a contract are that there must be communication, acceptance from the other party must be communicated. There must be communication between the contracting parties. When one makes an offer, the other one either accepts the offer or he does not accept the offer. For example, to accept the offer, he must communicate back that he has accepted the offer. But if he makes a counter offer, then he or she has not accepted that offer. Or if he remains silent, it means he or she has not also accepted the offer. So in a contract to be valid, there must be communication from the party accepting the offer, and also from the person also offering the offer must also communicate to the other party, so that the other party also understands exactly what the offer is all about, or what the contract is all about. So there must be communication. Also, in an over, there must not be any counter over. It must be unqualified. You either say yes or no. But at the moment you bring in other matters, that maybe it could have been like this, and if it could have been like this, I could have accepted. It must be unqualified. That over must not be qualified. When you are given an over, it must not be qualified. You either say you agree to the over or you don't agree to the over. Acceptance must also precede the over. You don't accept the over before the over is made to you. So first of all, there must be the over, then there must be acceptance, but not vice versa. The acceptance to come before the over, no. First of all, there must be an over, and then acceptance. Also, the acceptance at times must be implied, must be expressed or implied. For example, if it is expressed, it must be communicated by word. When you communicate by word, it means the other person will hear what you are saying and will know that you have accepted the over. But by implied over, it is just by the conduct. For example, if one makes an over to sell you land, and is selling you land at that much, and then you give him the money without saying yes or no, it means you have already, your conduct shows that you have already accepted to buy that land. So acceptance can be by expression, or even can be by conduct, your conduct. It can be implied by your conduct. That will be also acceptance. And also, acceptance must be made by a specific person. When an over is made to a person, it is that person to accept that over, but not a second or a third party to come in and say, oh yeah, we have accepted. No, it is the person that the over was made to accept or reject the over. So the over always must be specific to a particular person, and that particular person must accept the over or reject the over. It should be that way, but not, it should not be accepted by a third person. No. The person to whom it's made should be the one to accept the over or reject the over. Mode of acceptance is also important. Will it be a written over or by conduct, by implied action? For example, if an offer is made, the offerer may say, okay, if you accept it, you sign here, and then you sign. That's a written acceptance. Or if you accept it, you do it. If you accept this offer, then you pay the money. You go to a shop, you want to buy some clothes, and then you are told that the cost of this suit or dress is so much. Do you accept? You say you accept by paying for the price that was offered to you. There you don't have to sign anywhere. But there are certain offers that you have either to sign. For example, when you are buying you are buying a car, you can't just say you are paying, there is no receipt, there is nothing, there is no document to indicate that you bought this car. So certain things you can just do it by your conduct, shows that you have accepted, but there are certain valuable things at times you need to accept by signing or in writing that you have really accepted such and such a thing, such and such a offer. But also there's no mental acceptance, that my silence will show that I have accepted. No. Your conduct, yes, but not just silence. The other party may not know whether you have accepted or rejected. So you have to express yourself, or you have to show acceptance by your conduct, by paying the price that you have been offered to. You have to show by that action. Also, the offer must not lapse, must not lapse. For example, if the offer is made to you and you are told that within 1 week you should have either accepted or rejected the offer. But for you, you wait until the 1 week is over, is when you accept the offer. So that's a lapse of time. The time that you are given has lapsed. Therefore, that contract becomes null and void. And also, a contract may be terminated. In which way? A contract may be terminated by the death of the offerer. If you have been offered, if an offer has been made to you, and maybe before you responding to that offer, the offerer dies. The offerer dies before you accepting the offer. Then that offer becomes invalid, such that it becomes terminated. That action of his death terminates that contract. Also, as I've said, if you are given 1 week to respond to the offer, and that 1 week elapses before you responding. If you respond in the next 2 weeks, that offer, the time already expired. So it is also, that contract is actually terminated. Therefore, acceptance must be within a reasonable time. It must not be extended beyond the time given to you. No. It must be done within a reasonable time. If you have been given 1 week, and 1 week is 7 days, therefore, you should accept your offer within the limits of the 7 days. But when you go overboard and go up to 9 days, no, that one will not be accepted. Okay. When an offer is made, and the moment the other person that the offer is made to makes another counter offer to the other person who gave him the offer, who made the offer to him, then that means that offer becomes invalid. If there is an offer, it must be accepted or rejected. but not counter over. Once counter over is made, then the contract becomes nil and void. Null and void. It becomes null and void. And also, if a contract has been made, if an offer has been made, and it is discovered that the person who made that offer was insane, then that offer, even if accepted, cannot be valid. Somebody comes to you and says he wants to sell his house, or he wants to sell his land, but he discovered later that this person has not even communicated with his family, or his family knows that the person has become insane. Therefore, even if you accept the offer, it becomes invalid, null and void, in the circumstances of one becoming insane and volunteering to make an offer to the other, and he is discovered that he's insane, then that contract is null and void. Is null and void. And also there are other factors that may vitiate the contract. The factors are used in contract. There are certain factors also which may vitiate the contract made. For example, when you make a mistake, you render that contract void. The mistake must not exist at the time the contract is made, and must be one of fact. A mistake can be common, can be mutual, or unilateral. But where there is a mistake made, that contract will be null and void. Misrepresentation. The subject matter you are contracting at is different from the other one that is expecting from you. Misrepresentation may also cause a contract to be vitiated. For example, a statement or fact made by one party to the contract, which is one of the reasons that induces the representation to enter into contract. For example, one approaches the other with a view to cheating him, agree to something, whereas it's not what this person wants, and in the circumstance accepts the offer without knowing that this man has put in certain clauses that will make him not get what he had wanted initially. So misrepresentation also makes a contract null and void. There must be no misrepresentation. The other party must understand exactly what is offered. You wanted to sell a car, and the other party does not know that this car is not really a new car. You had used it more than the years you had told him, and then he buys that car, and the car within a few days breaks down. So on discovery, that the car was just a very old car, and the person did not really understand that it was an old car. He just believed your word, the word that was made to him, that this is a car of 1 year, that he had used it for only 1 year, whereas he had used it even for 7 years. So you see, in such cases, a contract, such a cases of misrepresentation, a contract becomes null and void. Also, there must be no duress, no threats to a party being offered a contract. You don't have to force that person. If later it's discovered that there was duress, then that contract also becomes null and void because there was duress. Somebody was being forced to enter into an agreement, into something that he didn't really understand. So, but he just signed because he was forced. So, in that case of duress, then that contract also becomes null and void. Also, there must be no undue influence that, oh, if you accept, these are the benefits that you will get, whereas there are no such benefits. So after the man has accepted the offer, later he finds out that whatever he was promised did not even exist. So that contract also becomes null and void because it was made under undue influence. And it was improper because it was done under coercion, overreaching, and cheating. Cheating was involved by influencing the other to accept what it does not even exist. So such a contract becomes null and void. Also, a contract may be illegal. For example, we have forbidden goods in this country, like the sale of drugs. When you enter into contract to sell these drugs, into a contract with one that he would sell you the drugs, and the said drugs are contrabands in Kenya, then is such a contract, if not, it cannot be enforced. It's null and void, so to say. So we have very many illegal contracts. For example, we have contracts to good morals. We have our own religious morals. We have our own social morals. But if you are going to introduce a contract which is contrary to the good morals that your society in which you come from have been upholding since time immemorial, then such a contract becomes null and void. For example, you cannot enter into a contract with your sister that you will marry your sister. That contract cannot be. That marriage contract cannot be. Because such a contract is contrary to the good morals of the community in which you belong. It has never happened. So such contracts that are contrary to good morals in society are also illegal contracts. Also contracts prejudicial to the family life. Contracts that okay, I'm going to marry you and you will not get a child. And if you, by coincidence, you get pregnant, then I divorce you. So let us make that contract. It cannot. That is a contract contrary to the family life. It's contrary to the family life. And such a contract will not be enforced, will be null and void. It will not be a contract of good marriage. Contracts also to commit a crime or a civil wrong. That you want to enter into a contract with somebody to rob somebody, to take away somebody's property without his consent. That is to rob a person of his property. That you have ended with another person, he has sent you to go and commit a crime, and he will pay you, and you accept. And maybe in the end does not pay you. You cannot go back to that man and say, oh, you promised to give me and this, and I really went and did my part as you had sent me. But you see, that contract is null and void. It is a crime. The contract itself was criminal in nature. It can't be enforced by a court of law. In fact, both of you will be in for it, for entering into contracts which are criminal in nature. Contracts are also bad where they interfere with the administration of justice. For example, you go to court and then you tell the prosecutor that although these things happened, but I don't want you to bring about these facts. Just bring weak cases, weak facts, which will make the judge find me not guilty, because the facts facing me are very flimsy, so that if I had an expert, if you had an expert, the prosecutor says there was no expert, and then the judgment at the end is delivered in your favor. You see, that is compromising the administration of justice. Therefore, such a contract will become null and void, and it is criminal in nature. And also, a contract also in restraint of trade. For example, there may be businessmen who may tell the other that I will be selling this and this, and for you, you will be selling other goods, so that I retain my customers as you retain yours. So entering such a contracts in the restraint of trade is also null and void. It is null and void. It's also null and void. So those are categories of illegal contracts. And also, a contract may be terminated by operation of law. For example, a contract may be terminated because the law in force does not allow the kind of contract you are entering into. So if the law does not allow the kind of contract that you are going to enter into with the other party, then that contract is terminated. Okay, lapse of time. You made a contract that between this date and this should have been done. But if time passes before that thing is done, then the lapse of time makes that contract to be terminated. Sometimes by frustration, you wanted to sell a house to somebody, you enter into contract, and then before even the sale of the house, your house is set up a place, your house burns, so you have no house to sell, and it was not your intention. So that the contract also terminates. Sometimes breach of contract may also cause a contract to terminate. That is a breach of contract. The other party does its part, but the other party does not fulfill its part. So either way, if the obligation of the other party is not done, then that contract terminates that way. Also, people, after signing contracts, they may come up and agree between themselves that although we had agreed to do this and that, but due to such and such circumstances, let us terminate this contract. Maybe the other party is going to stay in abroad, it will not be in Kenya anymore, and they had ended into a contract a few weeks ago to do one or two things. Therefore, they may come up, mutually agree that let us terminate this contract. That also can be done. Also, performance. A contract also may be terminated by performance. If the other party does not perform what they agreed to do, then that's also one way of terminating that contract. However, we have remedies for breach of a contract, for breach of contract. For example, in the common law, if you breach the contract, and if common law is applied, then you have to pay damages why you did not honor the contract. You have to pay damages. And equitable damages which does not actually put the other party at a loss, because the other party relied upon you, but for you, you have breached that contract, and in that way, the other party has suffered losses. Therefore, you will be required to compensate the other party to the position in which you were before the contract was breached. So, damages can come up using common law or even specific performance. We have damages which operate under the common law. And also we have specific performance. A court may compel the defendant to perform their part. This can be by way of injunction. It may stop the other person from doing what he's doing or to do what he is supposed to do. That is an injunction. Also, there is also another remedy called rescission. This may be granted by the court, which seeks to restore the parties to their original position by rescission. Also by rectification. Rectification occurs when the contract between the parties has a mistake which prevents it from reflecting what the parties intended to do. So a rectification can be made. And so, my good students, I want you to go and read widely the law of contract, and we will meet again, and then we will review what we have. I will review with you what we had learned today going forward. Bye bye for now.